that up as well. I commend the bill to the House.
The question is that the motion be agreed to. Honourable David Parker.
Thank you, Mr Speaker. Can I thank the Attorney for his comments? I endorse every one of them. I have confidence in his knowledge in this area of law, having sat with him on the Privileges Committee that considered both the effects of the decision in Attorney General Nguyen Lee and also the a quick reference through the earlier Privileges Committee into the effect of the Buchanan and Jennings decision to which the Attorney has referred. I'm not going to speak for a long time, sir, because I think the Attorney has covered issues well and I haven't got anything to add. But I would put on record that there is an enormous public interest in Parliament being absolutely free to talk about everything and to be unedited in their views about things that affect our country. Parliamentary privilege is meant to be absolute for parliamentary proceedings because the public interest in politicians being free to speak their mind, to accuse people who may be corrupt or incompetent of corruption and incompetence is, within the confines of parliamentary proceedings, more important than the private interests of the people who may feel that they're being defamed. And it's that fundamental principle that underlies parliamentary privilege, that there's the public interest in transparency and scrutiny that in the end keeps democracy clean and that enables dubious things that might be happening in society to be debated within this place in a way that is more likely for bad things to be fixed. And if we limit that the ability of Parliament to go about its business with the fullest of information and in the most frank way possible, then we do a disservice to democracy because we make it less likely that transparency and democracy will survive in the longer term. And it's for that reason that the Privileges Committee thought that the decision in Attorney General Nguyen Lee was wrong, because the effect of the decision was to write down and narrow what it is that is done within parliamentary proceedings, which is absolutely privileged. And the court found that all that was needed, introducing this doctrine of necessity, all that was needed by the system and by Mr Gow, who was alleged to have defamed Ms Lee, all that was needed was qualified privilege rather than absolute privilege. The Privileges Committee had some submissions from some pretty notable people with experience in these matters and academic expertise. Professor Joseph, Justice Hammond, to name but two, thought that the court decision, with due respect to the court, was wrong and that Parliament should overturn it. I always made the point in the earlier debates around these matters that I didn't concede that the court had the jurisdiction to narrow parliamentary privilege. I agree that this bill is the way to resolve it, but I never conceded the jurisdictional point, and I still don't. And the reason I don't is that I think that there are some matters of contest between the courts and the Parliament where there will always be a grey area in the middle, and that but that underneath it all there will be this sort of push by the courts sometimes and pushback from Parliament as we sort out where the line properly lines in these areas of grey in the middle. And the only way to avoid those areas of grey is to try and codify and define them. And I personally don't think that that's a good idea because codification and the risk that we would give over to the court future interpretation of that code in itself poses dangers that are best avoided. And I prefer to carry on as Westminster Parliaments have since the Bill of Rights was passed back in 1688. Is it 1688? 1689. Thank you. 1689. Thank you, John Banks. He was in Parliament then. I prefer to leave it for us to manage these issues as they arise. And I like the prospect that in some future time when Parliament is less responsible, that there might be a pushback from the courts if the Parliament goes too far in the exercise of its jurisdictions. And similarly, if the courts go too far, I like the greyness of these lines to allow pushback in the other direction. And through those mechanisms, we actually get to a pretty sensible outcome in New Zealand. Indeed, we've got a very long, unbroken democracy as a consequence of the way we run our constitutional arrangements. Nevertheless, I agree that we, having reached this point in respect of parliamentary privilege, the practical way, rather than to deny the jurisdiction of the court to make their decisions, is to actually remedy it by way of statute, because no one doubts the supremacy of Parliament's ability to write a statute in this area and correct what set out the position as we think it ought to be. And that's what this Parliamentary Privilege Bill attempts to do. Mr Speaker, I've got no doubt submissions will be made to the Select Committee by people interested in these matters, and I look forward to hearing those submissions.
Honourable John Banks.
Mr Speaker, I must say I've enjoyed